Hey everyone, Harry here to talk about the last case that issued today, the Moyle case, which was the case that inadvertently surfaced for a very short time yesterday. That's kind of a story in and of itself. You know, the Supreme Court with an oopsie on actually issuing of an opinion is really a bit of a stunner. And also, why didn't it issue? Remember, yesterday they only had two, so this would have been a third, which is nothing remarkable. There must have been some way in which it wasn't ready, and now I think people will pore over the opinion and kind of see it. But it's a very interesting opinion in a lot of ways, or it's not opinion really, it's a case, and a lot's going on there. Okay, so it's the first case since Dobbs in which the court reviews a state abortion statute. And it's Idaho's statute, and it's the case concerns the margin between, and part of the argument is it this or is it this? Idaho's requirement that there be no abortions unless necessary to prevent a pregnant woman's death. Talk about severe. Forget about it unless it's necessary to prevent a death. And that comes into conflict, it certainly would appear, with federal laws under the what's called the Emergency Medical Treatment and Labor Act. That's why you'll be seeing EMTALA in capitals as the description of this case. And that says that if you get Medicare funds, you've got to provide essential care to patients who are experiencing medical problems. And so that includes a class of cases in which someone is really experiencing, a pregnant woman, grave threats to her health or an emergency that is short of actually necessary to prevent her death. And this case has all kinds of really heartbreaking stories underneath, where while Idaho's law was being applied, and I'll explain how that came to be in a moment, you had women experiencing terrible health issues, threatening or in some cases resulting in infertility, but also terrible pain, future gynecological problems, stuff that it's just, you know, you're in an emergency room and you are in Idaho and you're having what anyone would say is a, absolute emergency. And the doctors are there saying, well, is it necessary to prevent death? Because we can't do it until that happens. And what's been happening while this law was permitted to go into effect by the Supreme Court, as I'll explain, is they've had to airlift. Happened once in the year before that somebody had to be airlifted out for some emergency. It happened weekly in Idaho. People come in, women come in. They're in grave need of medical care, but under the Idaho law, you couldn't say that it was necessary to prevent death. So that's the all important space where the case takes place. Okay, the procedural history matters here. So Idaho passes this law, and the federal government sues, saying, that you've got to enjoin this law because we're the feds, and A, you get money from us, and in order to take it, you have to agree to these things, and B, it's preempted. So, federal law is supreme, and that means in a situation where state law says, ignore her unless she's necessary to prevent her death. We have actual stories of, women in emergency rooms or outside in agonizing situations, but unless it's necessary to prevent death. Imagine like medical personnel being put in this position of having to make those judgments. The case was brought, and the district court enjoined, in other words, gave a stay and said, no, this looks like it preempts. So Idaho law, you're frozen. We can go and think about the trial, but for now, under the rationale for when you give a stay, that the balance of equities and likelihood of success, Idaho, no, your law is inoperative. At that point, the case went to the Ninth Circuit, which was figuring out what to do with it. And at that point, the Supreme Court reached down and took the case before the Ninth Circuit had ruled. So the kind of thing that, remember, Jack Smith asked the court to do, back last December, whatever, cert before take a case before judgment. It is rare. They reached down and took it, and most crazy, and today's opinion shows it was crazy, or more, most crazy is too nice a word, most aggressive, overreaching, radical, really, and just dripping with hostility for abortion rights. The court dissolved the stay. And so while over the last many months until today, from when it took the case, the Idaho law was operative. And so that meant the situation that when it came up for oral argument, we had all these questions, especially from Justice Kagan, pointing out what was going on there on the ground. So the court was considering the federal government's claim that there's preemption here, and there's also under the spending clause, because it's Medicare, they have to, if you take the money, you have to give the kind of essential care that we dictate for our Medicare patients. The Supreme Court was considering that, or that's what we thought. So that's second big point. So the first is how it operates and what it was really doing in that margin of cases. Second is the procedure and a real, grab of the case from below. And now the third is a little bit of Supreme Court inside stuff, but it matters. What they basically said in this opinion is, never mind, we made a boo-boo. What does that mean? The case that they granted, and when you grant, you take cert, they are dismissing. Why? So it's as if they never took the case. Never mind, let's go back to where we were before. Why is that? Because the case, it said, is improvidently granted. We made a mistake in taking it. Now, talk about a black eye or a bad situation to actually concede that, given that they dissolved the stay and forced these terrible consequences on the women of Idaho. But they, it basically was, there's a big argument in the cases. So now big point 3 is this a right case to dismiss as improvidently granted, which the Supreme Court does quite rarely, but it does do. Very quick inside story is when I was clerking on the court, a clerk by mistake suggested to them that they should take the case, but only for a particular question. And so the order went out, and then the briefs came back, and the clerk had identified the wrong question. And so what came back was, something that didn't seem cert-worthy at all, and it wasn't. They dismiss as improvidently granted. And it happens in a few different situations, but that was the argument is. So we have the practical impact that at least the stay at least the stay is reinserted, because it's as if the Supreme Court just erases what it does. And so now we're back to the situation where district court had granted a stay and an injunction, and it was on the merits in front of the Ninth Circuit. But there's a real sort of brouhaha in the court about whether they should have done that. Okay, so let's go now I'll just briefly detail what the justices said, and then I'm going to do another tape kind of going more in depth with the two most important opinions in the case. But so and the sort of argument about dismissal as improvidently granted. But the main thing, let's take the first opinion by Kagan. I'm doing this because they've never justified either emergency relief or our early consideration of this dispute. So basically, we should never have done this. The standards for a stay are you've got a really good case, you're likely to prevail, the balance of equities are with you, and as Kagan says, look, this is a straightforward preemption case. You have a conflict between federal law and state law. It's really, something that we shouldn't have been messing in, much less permitting the law to go into operation. It's really, straightforward. And then just in general, you have 6 members of the court for different reasons saying, so you have, 5 members of the court. So it's 5-4. Members of the court saying we should have not taken the case. Kagan just says, look, this was stupid. I said so that we shouldn't, this is just nothing that required us to intervene. And Idaho's case was really, lousy. Barrett, interestingly, what people are going to debate is whether it's an emerging center block on the court. But if there were, Kavanaugh, Barrett, Roberts basically say the case has changed. And that to me seems a bit of disingenuous, because what they're saying is arguments made in court make it look different now. And how did it make it look as if, Idaho in court said, after an opinion from the Idaho Supreme Court said, we're not as nasty and mean as all that. We do a little bit more than just, someone's about to die. And the Fed said, we're not as, easygoing as all that. There are things that we do that are, really, you got to think about. For example, the unborn child is mentioned in the federal laws. So, but that was as part of their arguments on the merits. But Barrett and Kavanaugh and Roberts seize on that to say it's now a different case from how it looked before. So that's the reason it makes sense to dismiss it as improvidently granted. Okay, so Kagan and Sotomayor say, never was, never should have been, nowhere near. We shouldn't have been near this case. Not that anything's changed. And the 3 others say it's now changed. So for that reason, it's right to say it was improvidently granted. Of course, even to put it that way shows the flaw in logic, because what they're saying is it was improvidently granted. You can dismiss a case for different reasons, but that dig really suggests at the time we made a mistake. And Barrett, Kavanaugh, and Roberts are saying something a little bit different and doing a little bit of fancy footwork to do it. Okay, so that's how you get to 5-4, and the result, which is, never mind, whole thing goes away. The writ is dissolved, and so we're where we were before when they did their, really aggressive intervention in the case, reaching out and grabbing it from the Ninth Circuit. Now it's back, and now the stay from the district court had entered is back in operation, and now women in Idaho who have grave medical issues short of imminent death or causing or necessary to save their lives can get reproductive treatment, including, and in some instances, this is also part of the argument, but including in some instances abortion. So we're back to where we were. Okay, so pretty complicated state of affairs, and a very sort of unsatisfying one. They do this whole thing and then just say, forget about it. But that's where things stand. And I think it's worth going in more detail into a couple of the opinions in the case. So I'm going to do that in a subsequent tape. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.